Good afternoon, everyone, and welcome back to this week's special episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we at Digital Law are a niche law firm specialising and working solely in the technology and cybersecurity law sector. In each episode, we look at recent stories in the news relating to digital technology from around the world, with a specific emphasis on data protection and cybersecurity. For more information about the specific links that we're going to be covering in this week's story, please click the link in our show notes for more information. By way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital UK, and I'm joined by Peter Wright and special guest Ella, who has kindly put together all of the research that we'll be exploring today. I will let them introduce themselves and then we will get started. So Peter.
My name is Peter Wright. I'm a solicitor and managing director at Digital Law, and it's good to be able to devote a whole episode to a really important topic because, as you quite rightly said, introducing this in terms of us as a firm there, Amelia, we do a lot of work in technology and cyber, and increasingly we do an awful lot of work around AI, and there's some really interesting things happening from a legal perspective when it comes to the use and application of AI at the moment. So really looking forward to this discussion.
Thanks, Peter, and over to you, Ella.
Yep, so my name's Ella. I am going into third year at university. I'm a law student, and I did a little bit of research on this case that we're going to be talking about today. So, yeah.
Thanks, Ella. So we are going to be looking at the Getty Images Inc. and other companies versus Stability AI Ltd. So this is a copyright infringement case at kind of a most basic level. Essentially, in 2023, the provider of internet-based visual and digital media content, Getty Images, brought legal proceedings against Stability AI, and Getty claimed that 12 million of its photographs, videos, and illustrations from its websites were used by Stability AI to train several versions of its deep learning text-to-image Gen AI model, Stable Diffusion. Ella, I'll pass it to you to talk about this in more detail on why Getty are suing Stability AI.
Yep, so Getty Images is suing Stability AI under copyright infringement, database infringement, trademark infringement, and passing off against the defendant. And this is under the Copyright Designs and Patents Act 1988. Also on top of this, that the Stable Diffusion, which is Stability AI's language model, basically used millions of images being produced by Getty Images to train this language model, and it's gotten to the point where Stable Diffusion's reproducing Getty Images trademarks on its generated images for that.
So you've given us a really good outline there in terms of why the case has been brought. What's Stability AI's response to Getty bringing this lawsuit?
Yep. So Stability AI are basically claiming that because they have trained its language model outside of the UK, that it's not held by the UK copyright laws with that, and also because the consumer is creating the prompts for the generated images, is that Stability AI are actually not liable for that infringement, because they the consumer can decide the degree of similarity of that output. And they also claim that is it's not a copy, it's imitation of the image. So,
Peter, you laughed there. I'll let you come in.
No, it's fascinating, isn't it? That I've only just realised the similarity there. Because it's like for years we've had the issue with regards to social media platforms where there have been problems with content that might appear on there. Say someone uploads something that is particularly offensive to a group of people, or particularly defamatory to a product or a service or an individual. And of course, the defence of the social media platforms would say, we are but the mere publisher. The actual thing at issue here has been uploaded by a user. And under our terms of service, it is the user that went and put this. It's nothing to do with us. We merely facilitated the technology that allowed this to happen. But the fact it's been done for this is nothing to do with us. And that it kind of continues to hold firm in the majority of instances. And it's always the sort of hoary defence that's and all that. And sure enough, that's exactly what we get here again. So they're saying, the fact that we've provided this AI is entirely irrelevant because it is the consumers that have used it. It is the consumer's prompt that is actually the thing here that's causing the problem. So it really is an extension of that sort of same, we are merely a platform and how it is used is totally irrelevant. You know, someone could use it for whatever purposes, and we merely provided the tech. And then the other aspect to it is the fact that, of course, well, what is this claim being based on? And I find it fascinating as well when you're just saying about the fact that we're looking at laws that are decades old. You know, British UK copyright law is decades old. And when that was being designed, the people that in Parliament that were talking about it, signing it off, would not have been able to envisage probably the use of the personal computer, let alone artificial intelligence. You could have a useful argument over whether they can understand AI now, but that's probably something to discuss at another time. But it's the fact we're trying to retrofit existing laws, saying that the existing principles around copyright should therefore apply to this medium, which really is a fair argument, because we're saying, well, in the real world it applies, so why on earth doesn't it apply in the digital world?
I think here's a good time to mention as well that when we're considering AI, we are looking at the UK regulation of AI, and that is not meaning that the EU AI Act is going to be regulating this particular area. Peter, do you want to go in here and talk about how AI is actually being regulated in the UK?
Yes.
Just as an overview.
So at a very basic level, there is no equivalent of the AI Act in the UK. The main thing that has been said from a regulatory perspective is that AI platforms should make sure that they continue to comply with the existing regulatory framework that any tech platform has to comply with. So in principle, they have to comply with things like the UK's Data Protection Act 2018, the Privacy and Electronic Communications Regs, the Computer Misuse Act. All of this existing technology is exactly what should be regulating, as well as things like the there's links to communications regulation, not privacy and electronic communications regulations. The Communications Act, I think, that was the one that was used. We talked about the Twitter in our last podcast. We were talking about Twitter and people being sued for the content of tweets, and indeed receiving criminal convictions for things said on tweets, which continues to happen, interestingly. You can just look at, for example, the people that were convicted in the UK of sending a tweet on the back of the rather upsetting events in Southport last year. But the point is that existing framework around the use of technology is what should apply to the use of AI. So therefore, AI has to respect personal data, and you have to have the same principles around international data transfer, the same requirements with regards to security of platforms. All of that has to apply, as opposed to in the EU, where you've got the EU AI Act that then, I believe, has systems whereby it identifies specific large platforms and then puts a series of regulatory requirements on those platforms, as well as then broader applications in terms of what organisations using AI have to do. So, for example, there has to be then training delivered on the use of said AI, which we've delivered for clients, interestingly, but there you go. Well, the point is that we've got quite a sort of hands-off approach to state regulation of AI in the UK compared to that more hands-on interventionist approach that you've seen in Europe, which is different again from the approach that you've got in the US, which is pretty much the Wild West.
And that's why this is such an important case within the UK, because this really is going to be setting a precedent in terms of how AI and copywritten kind of information is then being used. So, Ella, talk us through what the High Court's response was to Stability AI's defence.
So the High Court's response in general, there was actually a mistake on the Getty Images and the others claim, because the claimant actually didn't have the same interest as the other parties. So they couldn't proceed under the civil procedure rules. I think it's 19.8.
Yeah.
But Stability AI have actually, Getty Images and Stability AI have actually come to almost like an agreement for the first claim. And Stability AI has basically put measures in place so that the prompts complained of can no longer be used to generate synthetic outputs. But Getty Images is still pursuing the other claims, so the trademark infringement, passing off, and secondary copyright infringement. But I just want to know, I couldn't find much of how Stability AI has been able to do that. I mean, because they've used so many different images from Getty, how they're able to distinguish the ones that have been complained of and how they're no longer being used for the generation of prompts.
That's a really good point, because that almost suggests, because there's the concept sometimes used of black box AI, where you can't necessarily account for how it produces its answer, but actually the fact that that solution has been put forward by Stability AI suggests that they know exactly how their content is used to train the system, and then how that influences the outputs that it produces in relation to the prompts that its consumers give to it. And that suggests that they would have had to have a very clear idea in terms of how that operates in order to give assurances of any weight that would actually have been in any way meaningful to Getty Images.
I think the point here is that Getty were actually they were seeking injunctive relief against Stability AI continuing to use their images for training. So in a sense of them, Stability AI bringing those technical changes in, they say, well, realistically, they've achieved what they're after.
Yeah.
Which I do, this might be controversial, but I feel like Getty just kind of trying to save face here and say, okay, well, we're happy with this for now, but we're still going to keep our claims in relation to trademark infringements and the passing off argument as well. I think it's an interesting point to almost try and keep the case alive and just say, well, here's what we're willing to compromise on, and on to the next.
Yeah. It's also, I wonder, I mean, it's interesting the points there that you've identified in your research on CPR 19.8 and 19.3 in terms of what could and could not go ahead in terms of factors originally Getty and others versus Stability AI, and who could or couldn't join the action. And funnily enough, I was presenting a course for MBL yesterday on a totally different subject, but actually it involved digital assets. And in that instance, there were, I was using as examples high court claims where it turned out that the wrong party was being pursued. They were pursuing in that instance, a cryptocurrency exchange, when actually it probably should have been the owners of specific digital wallets that should have been pursued, and saying that the exchange was liable, again, for what the users were doing, was probably a bit of a hiding to nothing, which suggests not the best legal advice being given sometimes to parties that are throwing significant resources at bits of litigation. Not to say anything about the eminent firms that I'm sure are doing their very best to represent Getty, but it does make you wonder, in the stampede and the rush to get this to litigation on the road, did they throw and plead numerous things in this sort of, let's throw so many things at the wall and then see what actually makes it through. And almost like one of the biggest things in this instance didn't. And certainly they would have got to a point where they thought, we're not going to be able to make any convincing argument on this if we go through to a hearing.
Absolutely.
So I guess the follow-up here is sort of what's next. We understand that, there are still two ongoing claims that Getty are trying to kind of push through in terms of the trademark infringements and the passing off. But what are sort of the implications moving forward, for example, developers and other people using AI as we go forward?
So I'm not actually sure. What do you guys think?
I mean, I think one of the main things is in relation to output, because as Peter described earlier, the fact that essentially you're trying to say, well, it is the individual behind the screen that's putting out the prompt, which then is getting that output. And it's kind of how you train it to kind of spit that out. Even if training is lawful or maybe outside of jurisdiction, how this is used within the UK triggers potentially quite a big legal risk. And what is an appropriate way to train an LLM? Because the whole purpose of a large language model is that you need to train it on as much information as possible to make it as accurate as possible. Therefore, if you're then sticking to, for example, images that are not copywritten in any way, then you've only got a set amount of those that exist, unless you're then going to be going out and taking pictures yourself and then uploading them to your LLM, which seems like a huge undertaking. It's a quite interesting legal risk there, and then it's to say to developers, well, okay, how do I avoid and mitigate this risk? I think, Peter, we've discussed on the podcast before that some LLMs have come to deals with, I think it was the Times newspaper.
Yeah.
They've essentially come up with a deal so that they can train their LLM.
Yeah, so that's News Corporation, I think ended up being paid the thick end of about $500 million for access to, so that I think OpenAI could basically train their system using the entirety of things like the newspapers that they publish around the world, and the content, because the News Corporation includes things like Fox News and various other bits of audio and visual material, as well as the written words. The point is, they were saying, look, you can train on all of this, and at least we're getting something for it rather than nothing for it. That I think is the thing that upsets a lot of the providers like Getty, and more broadly, the smaller content creators that are out there who might be producing anything from blogs to articles to research papers to poetry to music to video to movies, where this stuff might be used to train an LLM. The LLM then produces content, and increasingly sophisticated content in terms of, potentially, we've already seen music produced that to the untrained ear might sound perfectly like a group playing something when in fact it isn't.
Yeah.
And we are far, well, I've seen video produced by these platforms as well that unless you know that what you're looking at has been produced by AI, it's pretty difficult not to tell it apart from a normal, it says normal, computer-generated effect that you might see in any other movie.
Yeah. I guess the interesting point here is, obviously, you've demonstrated the fact that, if you're a large corporation developing an LLM, you can essentially pay someone for their content. You could also argue that it could stifle innovation if you're then saying, well, actually, that's the only way that you can mitigate the legal risk of copyright infringement, if you have to physically ask someone for permission to use their content. And 9 times out of 10, someone's going to want payment for that. And if you are, trying to develop an innovative piece of technology, you've then got a bit of a problem, because surely you're going to want to then put all of that resource into developing the software rather than paying someone for their content. So you've got like an interesting balance that you need to kind of come up with here. That's why this is going to be quite an interesting precedent to watch.
It is as well, because from a policy perspective, the British government, in terms of its approach so far, for the last 12 months, they've been going around saying AI is the future. We need AI to help the health service. We need AI to increase the UK's terrible productivity, which is a brake on the economy. So they're wanting to talk a good game on, we are a great place where you can innovate and develop this technology and develop these applications. But if we've then got very restrictive laws on the use of content to train them, you're then going to get those platforms saying, well, this is great, but we can actually go off to another country, and not only will they give us some nice tax breaks, we won't have the restrictive laws and regulations that you now have in place that could limit the speed at which we can innovate and develop our models.
And that's quite an integral balance, because the whole point of the UK government not actually putting in specific legislation for AI is to allow for that innovation, and that really fits within their legislative programme at the moment, is to allow for innovation and to allow for digital and economic growth. And if you were to then introduce quite a restrictive piece of legislation in terms of content, you'd almost be contradicting yourself in that. But I think it remains to be seen in terms of whether that'll happen, and also what policy pressure is going to exist following this case.
Yeah. I mean, indeed, I think there is going to be pressure as the judiciary starts to, in the absence of any clear steer from government, they will end up sort of evolving what their view of the law should be, and rather inadvertently, from saying, "Oh, we want a light touch on this in the UK," you might suddenly find that something quite heavy-handed could come out that could therefore inhibit that perceived ability to innovate. And unfortunately, it's sometimes not the work of a moment to get something through the British Parliament.
No.
So, is there anything in the current King's Speech on this? No. Is there anything in the current government's manifesto around what it does or doesn't want to do around AI? Well, apart from we want to encourage innovation and blah, 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 it's quite difficult to then attach to that, we're going to do a bill that specifically does X, Y, Z. That's quite difficult. And the reason why I refer to the manifesto is that that's the convention. If it's in the manifesto, then the House of Lords can't fiddle around with it too much. If it wasn't in the government's programme, as outlined in 2024, then they can go, actually, no, we think we should fiddle with this and table some amendments and take that out, put this in, which could mean, that this stuff takes a hell of a long time to work its way through Parliament, and also means that by the time you get it through the sausage machine at the other end, it doesn't really do what you wanted it to do when you published the white paper.
I think as well it's very hard to be able to come up with a balance between content creators and then the AI platforms, because we saw in the past that you had Sir Elton John, Dua Lipa, some really big names that were pushing for significant controls in terms of how content can be used. And justifiably so, if you've worked hard to produce a piece of work, you do not want AI to then take it and redistribute it in a way in which you didn't want it to happen, and also in a way that you're not going to get paid for. So you can truly understand a content creator's perspective on this. But at the same time, you've got to find that balance between being able to then innovate and create kind of the future of technology. Because particularly within the music industry, you've only got a set amount of musical notes that exist. So there is only so much you can recreate the wheel. I know in other industries there is a little bit more room for creative difference, but particularly the music industry, you are limited. So it's where do you draw that line as well between what is one person's creative content and what is another, and where is that difference? And I think that goes back to a number of different copyright cases that have kind of been quite big over the last number of years. I know that Ed Sheeran's faced quite a few. And the bottom line has been, well, there are only a set amount of musical notes, therefore there's not a lot we can do.
Yeah.
So I think it'd be interesting as well to see whether there's a divergence between the different types of content and how they're regulated. Because as you listed before, you've got music, you've got literature, you've got poetry, you've got a whole range that may need different sort of balancing acts to be able to effectively award people royalties in a sense for their work, but also still support LLMs.
Yeah. And that unfortunately is a tightrope that has to be walked. And when you've got some very powerful voices on both sides, and you'll have very deep pockets from the LLMs in terms of their lobbying, but you'll have some very powerful and very influential content creators. Not to mention the fact that, of course, you've got that vast sea of people out there now creating things at home that could be music, could be video. Think over the years of all the artists who started out literally in a bedroom. Gareth Edwards, movie director, he started doing stuff on a computer in his bedroom. Now he works in Hollywood. You've got DJs, artists who literally start off in the bedroom on a laptop and then create things, but they have to be able to start. If their content is going to be hooved up by AI and then produced, you've got AI producing stuff that could be virtually indiscernible from an original person's content, but someone can use the AI generated one for free, whereas they'd have to pay a royalty for the original content. Well, that's just going to cut the rug from underneath your small scale content creators. So it's an incredibly emotive argument, and furthermore, it's something that in the future economy where the constant thing is AI taking people's jobs. Well, if that is the case and everyone is then at home trying to turn that side gig, the side hustle into something that's paying, well, it could be even more difficult if you've got AI stopping you getting anywhere with that. So there are a lot of implications to this in terms of what the future digital economy looks like. And I'm not saying, in the sort of next 10 to 15 years. I think that's potentially within the next few years.
Yeah.
Therefore, these principles do need to be, they can't be fudged, I think is the point.
Yeah, it does need to be very closely looked at. And it'd be interesting to see broader than just the UK stance, the stance that's taken, across the world, because you've mentioned that the US is essentially a Wild West for the time being. The EU has taken a different stance. But again, based on my understanding of the EU AI Act, there's not a lot in there in terms of copyright. So again, you've then got, perhaps in this case, the UK setting a broader precedent on a worldwide stage, which I do wonder whether that's why, steps are being taken quite cautiously in this area, so that you're not making any rash decisions.
Yeah. Indeed, no one wants to be rash, no one wants to sort of draw that line in the sand, but the technology is moving so rapidly that in the absence of any meaningful framework, the technology will make the decisions for you, and they will just go ahead and do it, because we know that the position in California for the last couple of decades has always been do it, build it, get it out there, and then deal with any issues that come up afterwards.
Builds your confidence, doesn't it? Ella, have you got anything to add there?
We're going a bit dark here, so please feel free to raise the mood.
To say with that as well, it's like, as you said, AI companies can just infringe on copyright materials without any legal consequences at the moment, and it does defeat the purpose of copyrighting your work for protection in the first place. And I think if Stability AI does win this case, especially with their stance on, because this is happening outside of the United Kingdom, then it means that if, for example, a company enforces UK copyright law, if anything happens outside of that, then it's pretty much useless, basically. So it'll be interesting to see how that plays out as well.
Also see how many loopholes are potentially closed that are currently being used. So I definitely think this is going to be a key piece of legislation over the next couple of years. I wish I could see into the future and see how this is tackled, because it's certainly interesting to see what we've got now, and like I said, what comes out of that sausage machine at the end of the day.
Yeah.
Because let's not forget, politicians, MPs, they are not going to have the same level of tech knowledge that perhaps other experts in the field do have. And unfortunately, they're the people that are going to be making the legislation around this. And that's sometimes a little bit of a problem, as you might have understood from our most recent podcast on the Online Safety Acts. Sometimes the lack of understanding does actually follow through into the legislation, and that can cause consequences, good and bad, but nonetheless, not always the desired consequences.
Yeah, and that's actually a really good point in terms of the sort of the jurisdictional issues here, and potentially trying to apply UK copyright to platforms outside of the UK, even though they are processing the data of UK citizens or UK content creators. You've got at the moment, in the absence of any rules, in most instances at a national or supranational level, there's nothing there. So you've got, therefore, attempts to sort of reach outside of what you normally think of as the jurisdiction. The UK, we've had it with things like this claim, and again with the Online Safety Act, trying to apply that to corporations located outside of the UK, but based on the fact that they are affecting the UK market. And indeed, I think 4chan have announced they were suing the British government, Ofcom, over this just this week. And in the same way, you've had, looking again at digital assets, like I was doing this week, even though FTX was based on an island in the offshore, it wasn't a US-based platform. You still had, it was the US Securities and Exchange Commission and the US law enforcement that ended up stopping blowing the whistle, raiding it. Sam Bankman-Fried is in a US prison serving charges, serving a sentence, even though the corporation was not based in the US and wasn't subject to US regulation, but it affected the US market, so they went after him that way. So in the same way, it's like this element of extraterritoriality is something that the laws that nation states come up with are continuing to now run up against, when you're saying, well, look, this is affecting our market and our people, even though it is based outside of our jurisdiction, therefore we are going to attempt to apply these laws. Similar thing happens with GDPR and the fact you've actually had fines applied to companies outside of the UK, so in Canada, for example. So that element of extraterritoriality and, for example, can you successfully sue a corporation outside? Can you apply regulatory enforcement to a company outside of the jurisdiction? Continues to be incredibly important. And the way that is going to be, will judgments be respected in that regard or not?
I think kind of that brings a nice end to our discussion today, unless Ellie, you've got anything that you want to add there?
I think that's everything, yeah.
Okay, in which case, that was our last discussion of the episode. And if you have any questions about what we have talked about today, please feel free to email us at admin@digitallawuk.com. A summary of today's stories and the key points that we've mentioned will be on our website, as well as links to the original stories with more information. If you'd like to hear more from us, including information about subscriber-only podcasts, webinars, and events, then please subscribe to Premium via our Patreon channel using the link in the show notes. And a big thank you to Anson Evaluate for helping to produce this podcast. And if you'd be interested to hear more about Anson Evaluate services, please take a look at their website that you can find at www.ansonevaluate.com, as well as their services that are offered on Patreon, and that is around cybersecurity and the Substack as well. Just a reminder, these episodes are available on our website, our YouTube channel and podcast channels as well, such as Spotify, Apple Music, Amazon, and please feel free to leave us a review. Thank you for listening, and we hope to see you again next time.